SJC-12106, Josephine Hensley and others, v. Attorney General and another.
Mr. Schiff, as soon as you get settled, you may commence. Thank you.
Thank you. May it please the court. My name is John Sofa-Sheft. I'm of counsel to the Bilotti Law Group. I represent the voters. We ask this court to decertify petition 1527 because the voters were significantly misled when they were told that this was going to legalize marijuana. It's going to do much more. And wouldn't a fundamental question of any voter be, what are you asking me to legalize? The definition of marijuana has been established in this state for 40 years. It's a 40-year fact. Marijuana can only have a maximum of 2.5% THC, tetrahydrocannabinol. That is a hallucinogenic substance. That's what gets you high. Beyond 2.5% THC, it is a Class C substance known popularly as hashish.
Well, is your complaint with the summary?
Yes.
Okay, so can we direct that that summary be corrected, or do we have to essentially decertify the petition?
Well, you should decertify the petition, and that has been the response of the court in all of the cases that have come before it, particularly in the Sears case in 1951. The summary was invalid, so the signature gathering process is fundamentally flawed.
Why do you say, though, that the voters will be misled about a product that you think they already don't know enough about if we make reference or are required to suggest, to hold that the summary should include criminal definitions or criminal levels of, that provide definitions of marijuana? Why wouldn't it be enough to describe it as this does, consistent with people's general understanding of this is marijuana, and it also includes THC?
Because people's general understanding and our legal awareness of marijuana is wrong. What people are being asked to legalize is marijuana, hashish, marijuana concentrate, and also food products, food and beverages containing unlimited concentrations of tetrahydrocannabinol.
But it says in the short form that it's marijuana including THC. So it's all those products that are marijuana, which includes THC, as well as products made from THC. And it's in the regulation that you become concerned about concentration. Isn't that the point of regulating, so you're not just buying stuff you don't know what it is?
Well, actually, Your Honor, in the summary, the first line of the summary is tragically misleading. It says, the proposed law would legalize the use and possession of marijuana, nothing else. It was only after prodding that the Attorney General added tetrahydrocannabinol to the yes statement. But even that is insufficient. You have to mention food products. This is the first time in the history of the Commonwealth that we are going to put a hallucinogenic substance. This is not my opinion. In the general laws, tetrahydrocannabinol is called a hallucinogenic substance. That was a decision made based on medical and scientific evidence by the Commissioner of Public Health.
Can we go back to Justice Cordy's question? I don't understand why correcting the summary wouldn't be sufficient. I mean, you say so yourself in your brief that that's something that you would be happy with. So why not?
Well, we wouldn't be happy with it. We offer it as an alternative argument at the end. It certainly would be something that the court might choose to do based on its overall equity power that's recognized most particularly in Mass Teachers Association and the Sears case. But really, what the legacy of Article 48 is that a really significantly misleading, invalid summary essentially nullifies
well, it's
the
not
signature
misleading
process.
if it's corrected. And the whole idea of the initiative process is to get citizens involved in the lawmaking. And
But
so
Your Honor, the people who signed to put this on the ballot, they were given misinformation. The only neutral source of information they had, the only thing that is required on the signature paper is the neutral summary from the Attorney General's office. And that neutral summary misled them.
Okay, so tell me which, I've got the summary in front of me. Tell me which sentence, which paragraph you claim is misleading. Is it the omission of information or is it the assertion of information?
Well, there's two major defects in this summary. The first is the voters are told this is to legalize marijuana. Marijuana is the tail. The dog is going to be hashish. If you look at Colorado, if you look at
Now,
Washington,
you say hashish. Hashish is not mentioned in any of our law, is it?
but hashish is a term that has been used in complaints, in indictments. It is known popularly. If you go onto the website,
is it?
What's that?
It's just, is it a substance with a certain level of THC?
In Massachusetts, anything over 2.5% THC
But you, I mean,
becomes hashish.
isn't it the case that, I mean, that if you say you want to purchase marijuana or you have marijuana, nobody's measuring whether it's 2.5%. I mean, there's nothing to say that the marijuana isn't more than 2.5% all the time. That's A. And B, does it make a difference, at least as I understand it, that the 2008 initiative that the voters passed to decriminalize 1 ounce or less of marijuana or THC, right?
That's correct.
So I guess I'm wondering, does that tell people that these two things go together?
No, I don't think it does. Decriminalization is not legalization, and it's not commercialization. And also, they were clear in that legislation what they were doing. They are limited in this initiative petition to the terms that they used. The term that they used was marijuana as defined under 94C. Well, marijuana under 94C, Section 1 and 31, only 2 statutes is a maximum of 2.5% THC. Anything beyond that, whether you want to use the word hashish or you want to use the language of the petition, at least the Attorney General could have put the language of the petition in there, which is marijuana concentrate. You have seen in your brief the things that are being sold and used are not the leafy, green, natural growing substance called marijuana that voters are misled to believe is involved in this law. They're things like shatter and earwax, they're honey butane oil, they're extracted and manufactured with concentrations of THC of 60, 70, 80, 90%. The edibles that we're seeing in Colorado now, 45% of the market, this is the industry's statistics, 45% of what is being sold in Colorado are food and beverages, which is the most dangerous. This is what they even refer to it as, beginning pot, first time pot, right? This is what we see adults overdosing on. We see kids going to the emergency room. Well, we had a student 2 weeks ago have an edible in Colorado, throw themselves off a hotel balcony. The point is, if you were a voter, wouldn't you want to know the most dangerous substance that you're being asked to legalize? I mean, think about it. If I filed an initiative petition to legalize fireworks, and the definition of fireworks included firecrackers, bottle rockets, cherry bombs, sticks of dynamite, and hand grenades, don't you think the voters would want to know? And if the AG put in the summary, this is an act to legalize fireworks, wouldn't the voters later come back and say, why didn't you tell me that sticks of dynamite and grenades were involved in that? Well, I'm limited to the language used by the proponents. That's essentially the argument here.
Mr. Scheft, you said that there were 2 ways in which the summary misled the voters. What's the second way?
The second way is the summary said this law will have no impact on medical marijuana treatment centers. And that is just completely wrong. What this law does is it takes medical marijuana treatment centers, which have been nonprofit, limited to patients with debilitating illnesses, who have to get a doctor's certification. It now gives them licensing preference. It allows them to sell all of these THC products. This is, again, it's really tetrahydrocannabinol that's being legalized. It allows them to sell all of these products for profit at the same location where 3 years ago they told the voters, don't worry, we're just doing nonprofit health care. Now, the fact that it would be one thing to at least mention the fact that the medical marijuana treatment center owners will be part of the implementation of the legalization and commercialization of cannabis and tetrahydrocannabinol. But this summary goes in the other direction. It's inaccurate. It says, don't worry, this has no impact on the medical marijuana
Well,
system.
technically, isn't that true? It doesn't change any of the statute that licenses and regulates medical marijuana places and
It's not even technically true, Your Honor, because the law of medical marijuana said this will be nonprofit at a location involving medical marijuana treatment facilities for patients with debilitating illnesses. Plus, from the medical marijuana law, there is a whole complex of regulations that have been passed by our Department of Public Health. The Department of Public Health is the agency. The Department of Public Health says no one in a medical marijuana treatment facility can talk about using marijuana to get high. They have to talk about it in a medical way. They can't have any windows, any advertisements. They can only have a nondescript logo on the door. When this law passes, the voters need to know that that medical marijuana dispensary that, gives something to a cancer patient, that medical marijuana facility is going to automatically have picture windows, a neon sign, a candy counter, and a THC slurping machine. That's going to happen.
Well, isn't that going to happen only if certain regulations are not implemented in a timely way?
No, because what the law said, it creates this new Cannabis Control Commission, but isn't it interesting that it says to the Cannabis Control Commission, you can create any regulations you want to carry out this law, except you may not tell medical marijuana treatment center owners that they cannot conduct commercial business at the location where they're conducting medical marijuana for patients.
In terms of, in the event that there weren't implementing regulations in place, and then they could do that, don't you think that those two things would be read together?
I'm sorry, I
So
don't.
that would be only in the event that they were authorized because there was no implementation otherwise put in place in a timely way. Don't you think that the regulation or what you just read to us would be read in conjunction with that, so that in that event, then they couldn't be prevented from doing it?
No, I think it's clear that it's two separate issues. The first is, you can't prevent me, if I'm a medical marijuana treatment center owner, from conducting commercial sales at the place where I conduct medical marijuana business. The second issue, which is equally troubling, is if the regulators don't act, we will automatically be able to do it. Even in Colorado, they said, if you run a medical marijuana treatment center, you may not conduct commercial business at your location. And even if the state regulators don't act, you have to at least locally be licensed. Here, it's the opposite. And in the preamble to this law, they say, oh no, this is really about making sure that the kids don't get access to these products. If that's true, why would you allow people to conduct commercial activities in the absence of regulation? Wouldn't you do the opposite? Wouldn't you say to the people selling these products, we will try to get the regulations done, but you have to wait until we have a scheme in place before you can do these activities?
Is any part of what you're saying something that the proponents and the opponents would do in the politics leading up to the vote? I mean, there's going to be a campaign if this goes through. So you would expect that the proponents, the advocates for one side or the other would be educating the public about what the consequences would be. Why is that the Attorney General's responsibility to lay all of that out for people?
I agree with you. So much of what happens is in the political arena. But Article 48 understands the danger of a popular initiative process that isn't appropriately regulated. And Article 48 set out 4 very simple safeguards: excluded subjects, a neutral description by the Attorney General, right? And there are other safeguards, but the most important thing
Well,
here,
clear and concise summary as opposed to description, right? After the
Well,
amendment to Article 48?
our position doesn't make this a non-clear and concise summary. It doesn't require any more space to say something correct in the first place. The statement that this law does not affect medical marijuana owners is wrong. That's got nothing to do with conciseness. The statement that this law legalizes marijuana is wrong. And to amend it to say marijuana, hashish, marijuana concentrate, and food products containing tetrahydrocannabinol are not a lot of words, given how central this is to the core of what they're trying to do. As I pointed out in our brief, the length of this summary and what would make it constitutional would not bring this beyond what the Attorney General routinely does in other cases.
But the fact of the matter is, your description is wrong because it's THC only that derives from marijuana and not from synthetics. So even your description that you just gave us is incorrect. I mean, this speaks to the difficulty of putting together a clear summary. Is that, I mean, it's correct. It's only THC that comes from marijuana, which is within the scope of this law, correct?
Absolutely. It's fine to be more precise about it. You're right. It's THC that is manufactured, extracted from marijuana. That's correct. But that is certainly something that is a matter of degree. We're not here quibbling. If the Attorney General had said that, if the Attorney General had said marijuana concentrate, there are many ways that the Attorney General could say what needs to be said. But to just say marijuana and marijuana products and expect that the voters will know the import of what's truly on the legalization agenda, that is just insufficient constitutionally. That's inadequate constitutionally.
All right, thank you.
May I just mention briefly our second point on this petition?
I'm afraid you have to rely upon your brief for that. Thank you. You're already about 6 minutes over the time.
Okay,
Thank you.
Thank you.
Mr. Toon?
Good morning, Chief Justice Gantz, and may it please the court.
Mr. Toon, I have read your summary.
Yes, Your Honor.
Having read your summary, I would have no idea that this authorized the infusion of hallucinogens into food and drink for sale at all. None.
Your
Don't
Honor,
you think the public, the voters, would sort of like to know that?
Your Honor, the summary clearly refers to marijuana products. The
Marijuana
voters-
products, okay, so marijuana products authorizes the possession of marijuana, its accessories, and marijuana products. I'm supposed to know that means infusing a hallucinogen into food and drink? Really?
Well, Your Honor, I think the problem here is that this court has repeatedly directed that the Attorney General can and indeed should use broad generalizations in the summary as opposed to details. Here she used the term marijuana products.
Not marijuana concentrate, as is used in the statute, not food and drink, as is referenced, marijuana products.
The definition of marijuana products in the proposed law includes many things, including
So you're going to
topical
have to
products.
read. So you're going to have to read the proposed law. You can't rely on the summary to find out what's really going on here. You're going to have to go and read the proposed law. Wasn't the whole idea of the summary is that voters aren't going to be able to read the proposed law? They're going to rely on the summary.
Well, they're going to rely on a number of things, Your Honor. They're going to rely on the summary. They're going to rely on the 150-word statements submitted by the proponents and the opponents, but the full text of law that's given to them in the information for voter guides and in the greater public debate about this law. The problem here, Your Honor, is that the term marijuana products includes many different things. It includes topical products, ointments, oils, tinctures.
Food and drink. Food and drink.
For the Attorney General to speculate about possible applications or to single out
Are you
potential applications
this requires speculation, you think?
It re-
You don't, the Attorney General doesn't know whether food and drink is going to be involved in what's been legalized here?
there are many different ways marijuana can be ingested, and we couldn't possibly all can contain them in a fair and concise summary. We have to use generalizations, and the term marijuana product captures all the different uses
But
that will be.
I mean, why is this an all or nothing proposition? I agree with you. You can't list brownies, cookies, ice cream, and every tincture possible. But food and drink and other products, I mean, it just seems to me it's a class unto itself, and it doesn't take a whole lot of words to talk about it.
Well, Your Honor, to back up, there has to be some exercise of discretion here by the Attorney General in crafting the
Right.
summary. And certainly, there are different terms that she could have used and different features she could have more or less emphasis to. But she is entitled to a certain degree of deference in the choices that she makes and the judgment that she exercises. Now, using the term marijuana products is clear, and people can understand what that means. To single out particular applications, they've argued for ice cream and candy, would unfairly slant the summary in a certain direction. We can't single out particular applications that might resonate more with voters. We have to give a fair summary of the entirety of the petition, and that's what the Attorney General sought to do here.
So help me to understand our authority here. I mean, I gather that if we say this is unfair, then the ballot is dead, because unfair means that those persons who signed the petition signed it based on an unfair summary. What if we find that it is not unfair to that degree, but that it is not as fair as it should be for the voters? Do we have the authority to revise your summary and order a revision of it?
Our position is the court does not have authority to order revision of the summary.
Why?
Because Article 48 contains no language permitting post-certification amendments to the summary. The summary's already been served as the basis for tens of thousands of voters to sign the petition, and the only remedy for a defective summary is invalidation of the measure. The court has only done that one time in the history of Article 48, and that's in the Sears case, where there is a one
Done what once?
Sorry, Your Honor?
Done what once?
Invalidated a measure based on a defective summary. In Sears, there was a one-sentence summary for an 8-page petition in fine print, and the court said that was unacceptable and invalidated the measure, even after enactment.
What's your closest case to this, where the argument was made the summary is misleading and the court said, it's okay?
Well, the standard that this court has articulated in the Sears case and the MTA case, the court will not substitute its judgment for the Attorney General on a matter of degree, and even a summary that contains an error will not be fatal unless, in the context of the entire proposal, the summary is significantly misleading and likely to have a major impact on voters. That is just not the case.
But what if we make the judgment that both of those things are true?
Well, in that case, Your Honor, we think the only remedy is invalidating the measure, but we don't think this comes close to that test here.
Don't you think the language about the medical marijuana treatment centers is just wrong?
No, it's not wrong, Your Honor. The summary states that the proposed law would not affect the existing law regarding medical marijuana treatment centers.
Which must be nonprofit.
I'm sorry?
Which must be nonprofit.
That's right.
And not sell other than for medical reasons.
And this part of the summary tracks what the proposed law says. The proposed law expressly states it shall not be construed to affect the medical marijuana law, Chapter 369 of the Acts of 2012. And it's true that the measure would authorize treatment centers to also operate a commercial medical establishment at the same location. This is exactly what happens in Colorado. But they wouldn't change the medical marijuana law. Medical marijuana operators would still have to be licensed by DPH. They would still be allowed to sell medical marijuana only to qualified patients, and they would still have to do so on a nonprofit basis. The fact that there could also be a commercial establishment on the same location would not change the fundamental law that applies to the provision of medical marijuana. And so the summary is accurate in that respect.
Now, what do we do about the fact that your one-sentence statement makes reference to THC, and you thought that it was fair to say a yes vote would allow the possession, use, distribution, and cultivation of marijuana, including THC in limited amounts, but your summary makes no reference to the word THC.
Well, let's start with a summary, Your Honor. First of all, voters know what marijuana is. It is at least debatable how familiar they are with the term tetrahydrocannabinol. Second, the proposed law does not, as you point out, I'm sorry, Your Honor.
You say they know what marijuana is, but I don't think that people think of marijuana as marijuana concentrate that's going to be infused into other kinds of products.
Well, I think these different kinds of applications can be raised in the 150-word statements.
You're the one who said that the people know what marijuana is. I'm not so sure about that. When you look at the range of what it is in this
Your Honor, I think it would be exceedingly difficult for the Attorney General to spell out every potential application of marijuana concentrate, tinctures, oils. It would be confusing to the voters. It would be overwhelming in detail. Her job is to give the voters a concise summary of what this provision does. And the provision will legalize the possession, use, sale, cultivation of marijuana. That is the focus of the law.
So why did you choose to say including THC in your one-sentence statement where it was not included in the summary?
Well, because we seek and receive input from interested parties at different stages of the process. No one raised this issue with us at the time that we prepared the summary. At the time that we prepared the one-sentence statements in the title, various interested parties, including the plaintiffs here, persuaded us that including that phrase in the one-sentence statement would be helpful to voters. And it would serve the purpose of the one-sentence statement, which is primarily to help voters identify the subject matter of the question. The Attorney General's judgment may evolve as the Article 48 process proceeds regarding what voters will understand, what kind of debate is likely to appear in the 150-word statements and in the greater press, and what will be helpful to voters at the ballot. And she shouldn't be locked into the terminology that's used in the summary. But the summary
So, I mean, that begs the question, is the Attorney General has an evolving understanding and appears essentially to have said, it probably is more fair that we make reference to THC to address, to at least make reference to this idea of marijuana concentrate. But it's not in the summary, and the question then for us is, do we have any authority to adapt to this evolving understanding that perhaps the summary should have made some reference to marijuana concentrate or to THC?
It's the fact that marijuana includes tetrahydrocannabinol as a component. As Your Honor points out, this measure does not legalize tetrahydrocannabinol in all forms. It does not legalize synthetic THC or other synthetic cannabinoids, and therefore it would be inaccurate to say that it does. And this is in contrast to the 2008 decriminalization provision, which did legalize both marijuana, or decriminalize possession of 1 ounce of marijuana or THC. This proposed law is very different. So we have to be very careful about the terms that we use, and I think we have been. But the fact that we think it might be helpful to voters that they might see THC reference in these statements to understand that relates to this matter. It's not just marijuana, but marijuana including the component of THC, doesn't mean that the summary is inaccurate. It is completely inaccurate.
So let's get to the bottom line. You say we have no authority to direct changes in the summary. The only remedy is to invalidate.
That's our position, Your Honor.
What about the yes?
The yes statement, this court can order changes to the yes statement if it finds there has to be consistency between the summary and the one-sentence statement in this
Or
respect.
consistency between the one-sentence statement and the actual legislation.
Well, I'm not aware of any inconsistency there, Your Honor. The one-sentence
Or the
statement.
inadequacy, let's put
sorry.
it. Or the inadequacy.
In your judgment, you have the power to order a change to the one-sentence statement. That's right. But to pull back, the Article 48 process is meant to give the people a process to initiate and adapt laws. And the Attorney General's summary is very effective in providing voters a fundamental understanding of what this proposed law would do. And even though the court may disagree with her judgment regarding particular terms or what features should or should not be included, it shouldn't take away from the people the fundamental right to vote on this very important legislation.
All right, thank you.
Thank you.